families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, and welcome to this week's edition of Families Divided. This week, attorney Ashish Joshi will be speaking to us on the roles of guardian ad litems and children's attorneys in cases involving parental and grandparent alienation. We also will be hearing from some of our guest presenters at our in-person conference in September in North Carolina. I do hope you'll be able to join us. We have so much planned. We'll be hearing about all of this right after these messages.
In families dealing with alienation, communication during conflict is often very difficult. This fall, Family Access, Fighting for Children's Rights, will present a special in-person conference to address that very issue. Using and Refining Interpersonal Skills will be held September 9th through the 11th at the Marriott Research Triangle Park in Durham, North Carolina. You'll learn from experts how to master skills that can reduce anxiety, anger, and stress in alienation situations. Join Event Director Elaine, the founder and president of Family Access Fighting for Children's Rights, and conference moderator Dr. Colleen Murray as they present a lineup of highly respected experts, including keynote speaker Dr. Jeffrey Gardier, plus presentations by Bill Eddy, Megan Hunter, Dr. Joshua Coleman, Dr. Mark Mosk, Dr. Mary Alvarez, Dr. William Bernet, Dr. Sue Kornbluth, Shazia Sparkman, and Lisa Rothfus. Mark your calendar now, September 9th through the 11th, for Using and Refining Interpersonal Skills, hosted by Family Access Fighting for Children's Rights, Steel Partners Foundation, and PASCA. Parental alienation is child abuse. Visit familyaccess.info for more details on the conference and secure your attendance. Seating is limited.
Hello, my name is Ashish Joshi, and I am an attorney practicing and focusing on family law. I am from Michigan, but I practice in courts around the country, and I handle cases involving parental alienation. Today, we are going to talk about guardians ad litem and minors counsel. Some of you may be familiar with this concept or the term guardian ad litem, often referred to as GAL or GAL. Some of you may not know what that is about. So let's talk about that. A guardian ad litem is typically an attorney, another lawyer who the court appoints to advocate for the best interests of the child. So in a case involving high conflict custody disputes or case involving allegations of parental alienation or allegations of domestic violence or abuse, family judges sometimes like to appoint a neutral professional to investigate the case, to talk to the children, talk to the parties, look at the evidence in the case, and then tell the court what's the best solution here, or what the court should do in the best interest of the children. And GALs are typically lawyers. They don't necessarily have to be in some jurisdictions. For example, in Michigan, a guardian ad litem could be a psychologist, could be a social worker, could be a school teacher. It doesn't have to be a lawyer. In Massachusetts, there are two different categories of guardians ad litem. One is a mental health professional, and another is an attorney. And depending on the case and the facts of the case, a court or a judge could appoint either one to be in charge of the investigation. A lot of people are optimistic about the role that guardians ad litem play. And make no mistake, a good GAL, a competent guardian ad litem, could really make a difference in a case involving parental alienation or child abuse. Why? Because a good GAL could investigate the case thoroughly, could interview the child, can look at the undue influence on the child that the alienating parent has, could look at the relationship that the child enjoyed before the divorce or separation, and then could argue to the court as to what needs to be done in the child's best interests. And generally speaking, judges are more amenable and open to arguments or recommendations made by guardians ad litem compared to the lawyers arguing for either party, because these professionals are considered neutral. However, be careful. If you are being asked to give your consent for an appointment of a guardian ad litem, or if your lawyer is suggesting that your case needs a GAL and you need to get one on the case, carefully vet the professional. You want to make sure that the GAL who is being appointed in your case is a competent professional. He or she is either an attorney, or if your state or jurisdiction allows you to have a non-lawyer appointed as a GAL, that professional has relevant and sufficiently deep background in mental health issues related to child alienment, alienation, estrangement, and pathological enmeshment. An incompetent GAL, or a GAL who doesn't have enough experience in these issues involving parental alienation, can really damage your case. Let's take a scenario of what typically happens in a case of parental alienation when you have an inexperienced GAL appointed on the case. You have typically a child who is refusing to see a parent, or you have a case where the child is resisting contact with the targeted parent, and a guardian ad litem who arrives on the case talks to the kid, looks at the situation, talks to the parent, and immediately falls back upon their intuition, professional intuition, or what we call gut feeling. If the child is, let's say, 12 or 13 years old and is strongly resisting contact with the parent, let's say, for the sake of their argument, that the mother is a targeted parent, and the child, a 14-year-old daughter, is strongly resisting the contact with the mother. Inexperienced guardian ad litem, without investigating the case thoroughly, might just jump to a conclusion that the mom may have done something wrong, or that the child appears to be very strong-headed and it would not be good to push the child or to, quote unquote, force the child to see the mother. So let's have a cooling off period. And this is the term that is often thrown around and used, a cooling off period, which means they advise the targeted parent, the mother in our example, to not push for the parenting time, to not try to enforce a parenting time, but to rather sit back and let the child come to that conclusion on her own and give some breathing room to the child. What these GALs and professionals fail to understand is that in a case of alienation, Such no contact or cooling off period often leads to further entrenchment or solidifying of parental alienation. Before you know it, weeks go by. The child becomes even more strongly aligned with the alienating parent. The targeted parent continues to be frustrated and continues to go without the contact with the child. And situation goes from bad to worse in a very little amount of time. And obviously, during these times, the guardian ad litem and the lawyers and the therapists and other people on the case continue to bill, monies continue to be spent, the legal cost spiral. And by the time months roll around and we have a situation of a new normal, and then the family judge wonders what's going wrong, why aren't we making progress? So before you say yes to a guardian ad litem, ask your lawyer, do you think this professional is a good fit for my case? Do you believe that this professional that you are recommending to me, the parent or the court is suggesting, has any experience in the area of parental alienation? Ask for a copy of their resume. See if these people, the person who is being suggested to you as a GAL, if they have written any articles on the issue of child alignment, alienation, estrangement, or related topics. See if they have made any presentations. By all means, you should ask your lawyer if you could interview them on the phone, and your lawyer could be on the phone if you ask them questions. But you want to make sure that the professional you are getting on the case as a guardian ad litem, for whose fees you will be responsible or partially responsible, is a good fit for your case. You are not looking for just another family law attorney, regardless of the amount of experience that professional has. It is not uncommon for lawyers to tell their clients that, oh, so-and-so will be a great fit on the case because they have been around for 2 decades, or they have had significant experience in the family law or family courts. That may be true, and that may be well and very much advantageous in many other cases, but it may not be enough for you, because parental alienation is a very specialized area, and the dynamics involved in an alienation case are very counterintuitive. And you want to make sure that the professional whose recommendation is going to carry significant weight, the professional who is going to have the ear of the judge, the professional who the judge is going to look at in terms of getting recommendations and suggestions, that person knows alienation inside out. The other professional sometimes who gets involved in these situations is minors counsel, or as some jurisdictions, such as New York, for example, calls them attorneys for children. And minors counsel and attorneys for children are different roles. They are altogether different creatures from guardians ad litem. A GAL, his or her obligation is to the court. They are the officer of the court, and their role and obligation or job is to advocate for the child's best interests. Not what the child wants, not what the child wishes, but what is in the minor child's best interests. So if little John wants or says that he wants no contact with the father, he wants the mom to have custody, and he wants never to see his father, a guardian ad litem is not required to advocate for that wish. A guardian ad litem could very well inform the court about the child's wish or desire, but then go a step further and explain to the court as to why it would be a mistake and a catastrophic mistake, a horrible mistake to give the child what the child appears to be asking for. Why? Because that child is alienated, brainwashed, and programmed into rejecting a parent. And the court should not go along with what is being described as the child's wish. But let's take a different situation. Let's assume that instead of a guardian ad litem, the court had appointed an attorney for the child or minor's counsel. In this situation, we have a different scenario and a different outcome. Many jurisdictions require the child's attorney to advocate for the child's wishes. And the child has the same expectancy of confidentiality from his or her attorney as you, an adult, would. So the attorney is bound by the attorney-client confidentiality. The minor child gets a loudspeaker, a megaphone in the court. The voice of the child is amplified. And that would be well and okay if the child wasn't alienated. But think about what happens when you have a brainwashed minor child who gets an attorney of his or her own. And if that attorney is obligated to advocate and fight for the child's wishes, the alienated parent, the targeted parent, has now two attorneys against him or her. The attorney who represents the alienating parent obviously would advocate for the alienating parent's best interests. But now you also have the minor child's attorney, the child who has been brainwashed into rejecting a perfectly decent, perfectly good parent. His or her attorney is now adding fuel to the fire and advocating for the child's wishes instead of telling the court what should be done in the best interest of the child. And this is an important part of the case when it comes to that crossroads. So when you are faced with the choice, when you are being asked to go along with the suggestion of a guardian ad litem or a minor's counsel, think it carefully. Have a detailed discussion with your lawyer. This is not a decision you want to make in haste. This is not a decision that you want to make in a cavalier fashion. You need to do your homework. You need to be able to interview or at least research this potential candidate who is going to come onto the case. Unfortunately, in my experience, I have seen guardians ad litem appointed without a second thought. It is not uncommon for lawyers to go back into the chambers and have a conversation with the judge, which is not part of the record. And they come out and they basically tell the client, well, we talked about this and the judge recommended so-and-so as a guardian ad litem, and he or she is a good lawyer, a good professional. I know her well, I know him well, and that's going to be a good thing for you. Maybe it is, maybe it's not. But once you have a guardian ad litem appointed on your case, it is extremely difficult to get them off the case. Even in cases where you can demonstrate bias, even in cases where you can demonstrate inactivity or failure to do a proper investigation, judges do not typically remove guardians ad litem once they're on the case. And a GAL who is not well-versed in alienation and the alienation dynamic is not going to look at the situation in the manner that it needs to be looked into. or investigated, there is a significant risk that they are going to miss the alienation. They are going to take the child's complaints against a targeted parent on face value, because alienation is highly counterintuitive. Let's talk about a different topic, but related one. Now that you have a guardian ad litem, what can you do about it? What should you do about it? Talk to your lawyer into how to present your narrative and your proofs of alienation to the guardian ad litem. Instead of throwing everything that you have, your voicemails, emails, photographs, all the proofs that you have gathered, and just assume or hope that the professional puts it all together and hope he or she gets it, give it to the guardian ad litem in an organized manner. It is important for the GAL to see what was your relationship with the child before the alienation set in. It is important for the guardian ad litem to look at the baseline relationship. Put together the proofs of alienating behaviors that you have. Every time your parenting time has been interfered with, every time the police officers were sent to your house to knock on the door and check on the kid who was perfectly safe with you, every time the other parent sent a text to the child while the child was having parenting time with you, inciting the child to call the CPS or asking questions that would lead the child to believe that you are an unsafe parent. Any photographs, any other witnesses who have observed the alienating parent badmouth you in front of the child, relevant pediatrician reports, relevant protective services reports, put it all together in an organized manner, preferably in the 5-factor model, and then give it to the guardian ad litem. Make the professional's job easier. Help them so that they can help you. And this is extremely time consuming. And your lawyer needs to help you to get this documents and materials organized for a guardian ad litem's review. With the minors counsel, it's a different strategy. You have to approach the minors counsel. You have to win their confidence. You have to explain the situation as to why what their client, quote unquote client, is telling them is not the reality, that the minor child believes that you are an unsafe parent and why that is not true. But these professionals can make a tremendous difference in your case, in a positive and in a negative way. And it's very important that you walk in with your eyes open and you give them the tools that they need to do their job. And if they don't be shy about challenging their opinions. Many lawyers believe that if a guardian ad litem is recommending a course of action, they must just abide by it, or it's futile to argue against it. I don't believe so. There are many cases where the courts have rejected the opinions or recommendations made by guardians ad litem. And if the GAL's opinion is absolutely inaccurate or flies in the face of evidence or science, do not be afraid to call that out. Do not be afraid to challenge it. There is a way to do it, and you can do it in a professional and respectful manner, but you can point out your differences of opinion from what the GAL is recommending, if that is truly against the weight of evidence and science. So if you get an opportunity, or if you are being asked to consent to the appointment of a guardian ad litem or minors counsel, take a deep breath, sit back and think about it. Know your rights, research your options, research the professionals who are being recommended to you, and then make a decision.
At Victor's Crown, our focus is on you, our clients. When you arrive, our goal is that you will feel at home, from our welcoming atmosphere to our serene surroundings. Everything we do at Victor's Crown is done with our clients in mind. We have comfortable seating areas for both adults and children. A large screen TV with surround sound where clients can be occupied with wholesome entertainment while they wait. We offer complimentary refreshments such as coffee, tea, water, and snacks. Due to the present COVID pandemic, our in-person appointments are restricted to selected cases, and those are held in our luxurious outdoor open-air meeting space that we affectionately refer to as the COVID Cabana, which was built specifically for our clients to offer them the most comfortable and relaxing outdoor space available. All our other clients are offered secured web-based telemed sessions where they can connect with us from anywhere in the world.
Hi, I'm Bill Eddy, and I'm going to be one of the speakers at the conference in September. I'm going to be speaking on overcoming the contagious emotions of alienation. And people don't realize how significant emotions are in alienating children. And what I'll be talking about is the dynamics of how emotions are contagious, a little bit about the brain, a little bit about personalities who tend to have excessive emotions that overwhelm children so that they either try to satisfy the person by just giving up themselves and thinking like the other person, or really want to escape that person.
Hello, everyone. My name is Dr. Jeff Gardier, better known as America's Psychologist, and I'll have the honor of delivering the keynote speech, Parental Alienation, It Can Happen to You. When we think of parental alienation, we usually think of an evil parent turning a child against the other parent for their own gain. The reality is that even well-meaning parents who may be in conflict and have the best interests of the child at heart can unconsciously or passive-aggressively participate in parental alienation.
Next week on Families Divided, Dr. Colleen Murray talks with two alienated grandparents, Elaine Simmonds and Jeff Morgan. Find out how to find peace in the heartache.